Hi, Gigi. Can you hear me? Can everyone else hear me now?
Yes, we can.
Great. Well, thanks, Gigi. Thanks for that wonderful, moving intro music. I hadn't heard that before. A warm welcome to everybody that's joined us here online for this EBO webinar on CS-DDD. If you've joined us for this event, you obviously already know a little bit about what CS-DDD is, but what you might not know is where this invite has come from. This event is being hosted by the EBO Worldwide Network. That is the European Business Organization Worldwide Network. I am the vice chair of this organization, and we are an organization that is composed of a network of European business organizations from around the world in over 50 different markets. And we come together to support each other in capacity building, in best practices, and helping each other do what we do as chambers, as business councils in our respective markets. The one thing that interestingly unites us is that we all have an interest in Europe, obviously. And every now and then there's a new piece of legislation or initiative that comes out of Europe that has an impact on not just Europe, but countries outside of Europe where our members, our European members, are also operating. That is why for the past 2 years, our organization has taken a particular interest in the CS-DDD. We've hosted a number of events, and earlier this year, we wrote a position paper on the CS-DDD based on feedback from all of our members around the world. We've made some advances since then, since the original proposal came out from the Commission to its adoption by the European Council in May this year. We're now starting to see the rubber hit the road with more and more details coming out. And as such, we should all take a greater interest, and we can see clearly from our members their interest growing as well. Today, we have online with us over 100 different participants. This is particularly of interest to our speakers who probably want to know exactly who they're speaking with, and that is you're not only speaking to the secretary generals and executive directors of our 50 members, business organizations from around the world, but we've actually invited our board members, our working group chairs of our respective working groups, and our members of our EBO members to join as well. So we have a very diverse group, people joining from Africa, from the Middle East, from Eastern Europe, from the Americas, and from Asia. We have a 1-hour session here. We keep it to lunchtime in Brussels. We're very, very pleased to have with us from the head of unit of DG Daniel Dionys, and as well a partner from Herbert Smith Freehill, Anthony Crockett. We did a similar event a few months ago. It worked extremely well with our members here just in China, and now we want to do it at a global level. So we'll start off with a 20-minute presentation from DG Justice, followed by a presentation from Anthony, and then hopefully we'll have another 15-20 minutes for Q&A. And so with that, I'd like to thank our speakers, Daniel and Anthony, and I'd like to now hand over to Daniel.
Hello, good afternoon there. Can you hear me first? Because I had to change my audio settings. Okay, just to say that I'm also joined here in the room by Zsofia Kerecsen, who's the team leader for corporate sustainability, and she was not able to connect from her office via the computer. So she's here. She's hearing the conversation, and. Yeah, I might not hear perfectly, so in case I don't understand, I might ask you to repeat. But if I understand well, you're expecting me now to give a first presentation on the CS-DDD, and then there will be another one before the Q&A session, correct?
Correct.
Okay, so I'll try to share my screen. Can you see it?
We can.
Okay, perfect.
It's not on presenter. Just to be clear, it's not on presenter mode though. It's on.
Yeah. I'm putting it now. Yeah.
Okay.
Okay. So thank you for the opportunity. I'll try to give as quick an overview as possible, and hopefully have time within this 1 hour slot also for some interaction and to hear from your audience. So just a brief recap of where we stand now. This directive on corporate sustainability due diligence has entered into force in summer on 25th of July. And member states now, this being a directive, they have 2 years to transpose it into national legislation. This they have to do by 26th of July 2026. And then it will start applying in a staggered way to companies, depending on their size, as of 3 years after the entry into force, meaning in 2027, July 2027, to the largest companies, then 4 years to still the large ones, but a bit smaller, so 28, and in 2029, 5 years after entry into force, to the full set of companies within scope. And I will come back to those. Also to flag is that we have a special review clause within 2 years. So by July 2026, the Commission has to look into possibly adopting tailored due diligence duties for financial services and report to Parliament and Council, accompanied, if appropriate, this report by a legislative proposal to establish such due diligence duties for financial services. What the directive is about, it's this due diligence duty, which is mainly identifying and addressing potential and actual adverse human rights and environmental impacts in the company's operation, the operations of the subsidiaries, as well as those of business partners in the chains of activities of the companies. So I mentioned the size of the company, so the personal scope, and this you will see all the companies that fall under this directive are companies with EU companies with over 1,000 employees and over 450 million net turnover worldwide, as well as non-EU companies that have a turnover in the EU of over 450 million. So these are the, let's say, the main groups of companies covered. We also cover, parents, ultimate parents of groups of companies that reach the threshold on a consolidated basis. So even if the ultimate parent individually doesn't reach the threshold, but on a consolidated basis reaches the threshold, is captured in the scope, as well as some franchising and licensing companies that pass certain thresholds worldwide or in the EU, depending on whether they are non-EU or EU companies. Just to make it clear that these covers, as you can see, large companies, the companies that are not directly within the scope, in particular SMEs, they don't get any legal duties under this directive. There is no enforcement or sanctions against them, obviously, because there are no duties, and they're also not subject to civil liability provisions under the directive. Now, what this is about in terms of material scope, first, referring to the adverse impacts, the directive is covering human rights impacts and environmental impacts. And these are, there are exhaustive lists in the annex to the directive, based on the international conventions related to human rights, other international conventions, and also these will be updated with the conventions that international instruments that are being ratified by all EU member states, such as some ILO conventions may be added later. When it comes to environmental impacts, there is also a list of prohibitions and obligations based on international instruments, and also points related to the human rights implications of environmental degradation. This is the fine print, but it's basically a summary of the annex. Again, material scope, what is the part of the value chain that is covered? We're talking about the upstream value chain, which is covered quite comprehensively. So activities of business partners related to the production of goods or the provision of services by the company, including design, development, sourcing, transport, and storage. When it comes to downstream, the coverage is somewhat more limited. It refers to the activities of companies, business partners related to the distribution, transport, and storage of a product of that company or service, and only where these activities are carried out for the company or on behalf of the company. Now, I mentioned earlier this review clause related to the financial services. Currently, this definition of the downstream chain of activities obviously does not capture the nature of financial services provided to clients, for instance, credit, insurance, investment. And this indeed will be the subject of this review in 2 years, possibly with the legislative initiative proposing tailored due diligence duties for financial services. What are the duties assigned to companies within scope? First of all, just to highlight that the general principles are that due diligence is risk-based, and it consists in appropriate measures. Appropriate meaning measures that are effective, commensurate, reasonably available to the companies, and also considering the circumstances that they are in. First of all, it's about making due diligence part of a company's overall business model, policies, risk management strategy. And the first stage is to identify, assess, where necessary prioritize based on a risk analysis, actual or potential adverse impacts. So it starts with a broad mapping and then going into an in-depth assessment where the main risks are identified. And the prioritization also of appropriate measures is based on the severity and likelihood of the adverse impacts. Then these appropriate measures have to be taken to prevent or mitigate these impacts, or bring to an end or minimize their extent. This can be done via preventive or corrective action plan where necessary. Contractual assurances can be used in the chains of activities, but these have to have fair and reasonable terms. This can be cascaded, for instance, through the supply chain. The companies will have a duty to make financial or non-financial investments into their value chains, adapt their plans, strategies, and operations accordingly, including, for instance, purchasing and distribution practices. They are expected also to support support SMEs where needed in their value chains, including with capacity building, training, sometimes where really necessary, even financial support. And they can also collaborate and are expected to collaborate with other entities, other companies in doing due diligence, increasing their leverage where needed in the value chain. Where impacts have occurred, there is also a duty to remediate. And only as a last resort, where none of these due diligence activities can improve the situation, there is this measure of temporary suspension of termination of the business relationship with specific conditions in case we're talking of severe impacts, and it also requires an assessment of whether the impacts from termination or suspension are not more severe than those that have to be addressed through due diligence. Also, companies have a duty to engage meaningfully with stakeholders at some specific steps of due diligence, to establish a complaints procedure for those affected by negative impacts, as well as a notification mechanism of such impacts or risks that can also accept anonymous notifications. They also have a duty to monitor the effectiveness of their due diligence, report about it. Reporting is covered for the vast majority of companies within scope by the already existing Corporate Sustainability Reporting Directive. For those not covered, which are mostly some non-EU companies without a presence in the EU, there will be a delegated act explaining what they need to report. It's a lighter reporting duty that the full CSRD reporting, because it only refers to the due diligence duties established by this directive. So this will be settled through a delegated act by end of March 2027. Another duty for companies within scope is to adopt and put into effect a climate transition plan. And this applies, by the way, to all the companies within scope, including the financial sector. Such a plan has to ensure compatibility of their business model and strategy with the net zero targets. The minimum content of the plan is also specified in the directive, so it has to have time-bound targets, including for absolute greenhouse gas emission reduction for scope 1, scope 2, and scope 3 as well, where appropriate, decarbonization levers, key actions and financing for this plan. So their duty is to adopt the plan, to put it into effect, and to update it regularly on an annual basis. The implementation of the plan is an obligation of means. So there is language both in the recital explaining how this is an obligation of means, but also the legal text speaks of best effort. Now, if the companies report such a plan, a climate transition plan under the Corporate Sustainability Reporting Directive, they are considered to have complied with the duty to adopt the plan under the CSDDD. But of course, in addition, they have this obligation to put it into effect and to review and update it regularly, including to reflect the progress achieved. Also to mention is that this obligation related to the climate transition plan is not subject to liability, is not part of the due diligence duties that I explained before. but is subject to administrative enforcement. There are a number of, let's say, facilities for companies within scope to make it easier for them or more efficient to implement their obligations. And there are support measures and safeguards for the business partners in their value chains that may be impacted indirectly. There is quite a list of such features in the CS-DDD. Happy to delve into this if there is an interest, but overall, just to say that you know, when it comes when comparing to other due diligence legislation out there, this is certainly the most business friendly, the most SME friendly, because we also drew from the lessons learned, for instance, in France, in Germany. But you know, it starts with this risk-based nature of due diligence. It allows to share information and resources within groups and with other entities. It encourages the use of digital tools and technologies in carrying out due diligence. As I mentioned, there are no new reporting requirements, and those covered by the CSRD, which is, again, the vast majority of the companies, don't have any additional reporting duties. Termination only as a last resort. There is a possibility to use industry schemes or multi-stakeholder initiatives, independent third-party verification at all the steps of due diligence where applicable. There are some clear conditions attached to civil liability that circumscribes it to very specific situations, but I'll come back to that. And when it comes to SMEs and other business partners in the value chains, first, the very risk-based nature of due diligence, let's say, reduces the burden on them, because there is no, you know, the large companies will have to focus their due diligence actions where the risks are. Also, their information requests have to go whenever possible directly to those levels in their value chains where the risks are present. They have to adapt their purchasing practices, and this is very relevant for SMEs, for instance, because this includes payment terms, conditions, prices. There is an investment duty for the large companies with regard to their value chains. As I mentioned, also can go to direct financial support to SME business partners. Contract terms, where contracts are used to implement due diligence, including contractual cascading. Contract terms have to be fair and proportionate, and not transfer the burden to the smaller business partners. When it comes to verification, the companies in scope, the large ones, have a duty to cover this cost, but also SMEs have the option to participate in covering the cost of verification, but then that gives them the possibility to use the results in relation to other business partners, to other buyers. And there will be also support targeted at SMEs, both from member states and from the EU level, financial support, information, capacity building, and so on. So this is a quick overview. In terms of, there is now quite a range of accompanying measures and guidelines that the Commission has to issue in the coming period. Guidelines, for instance, in general on the due diligence process at every stage, but also model contract clauses for the usage of contracts in carrying out due diligence. How to assess risk factors, guidance on data sources and digital tools for due diligence, on climate transition plans, on how to share information and resources with other entities, for stakeholders on how to engage with companies as part of or under this directive as part of their due diligence, as well as possibly sector-specific guidance as needed. And there are deadlines set for these specific pieces of guidelines. The way we are planning to proceed is to start with an open public consultation that will serve both as a call for evidence, collecting experiences, good practices out there, but also as a needs assessment and gap analysis to see where the biggest needs are, and that will inform also the prioritization of our work in addition to the legal guidelines that we have. And for this, so we expect to launch this open public consultation in October, and I would count also on your members to take part. Then in developing the specific pieces of guidance, we will reach out again to stakeholders, and there will be further consultations, but then on let's say, for specific outputs that have to be produced, these draft guidelines as they come out. The broader range of accompanying measures at various levels. So levels of the level of the member states, they are expected to provide information through dedicated websites, platforms, portals. They can provide financial support to SMEs that are part of these value chains, support stakeholders in exercising their rights, and the Commission can complement that, both in the EU and in third countries, for instance, when it comes to supporting business partners. The Commission has to establish an EU single help desk, which will cooperate with the help desks in member states. And at the company level, as I said, there is the possibility to participate in industry schemes, multi-stakeholder initiatives, use third-party independent verification as a way to really facilitate implementation and make it efficient. The Commission will facilitate such initiatives and will provide guidance to companies on how to assess the fitness and the effectiveness of these multi-stakeholder initiatives. Enforcement has two dimensions. One is the administrative supervision by independent authorities designated by the member states with adequate powers of investigation and enforcement, including the possibility, for instance, to issue injunctions and penalties. There will be a EU-level network of supervisory authorities to ensure, let's say, a coordinated approach to enforcement. Penalties have to be proportionate and dissuasive, and there is a cap, a minimum cap. So member states cannot put a cap to financial penalties lower than 5% of the company's net turnover. Civil liability can come into play where there is harm to a natural or a legal person's legal interests protected by law, and this is caused by failure to comply with due diligence obligations by the company in scope. To be clarified also, and it's explicitly said in the legal text, that if the damage was caused only by business partners in the chain of activities, the company cannot be held liable for that. There are also some safeguards to facilitate access to justice by those harmed. For instance, limitation periods cannot be lower than 5 years. There can be action through representation, for instance, by human rights NGOs. Courts will have a power to require disclosure of evidence or issue injunctions, and also safeguards against such access to justice having prohibitive costs. The last slide is a summary of the expected impact of this directive. So, of course, to improve human rights protection and the protection of the environment, including, living wages, living income, working conditions, to empower local communities and other stakeholders through meaningful engagement with the companies. So part of the company's duty to engage meaningfully with stakeholders, but also access to remedies. For the companies, we also expect benefits in terms of increased competitiveness and resilience through, let's say, better engagement with their supply chains, resource efficiency, better risk management, innovation, access to finance. Eventually, we think this would be strengthened if there is let's say, an extension to financial services through this review clause that I mentioned earlier, as well as for companies that are partners in the value chains. There will be support, target support, and capacity building. And overall, of course, this directive will help advance the sustainability transition, including when it comes to climate change mitigation. So I will stop here. I hope I didn't take too much time.
It's okay, Daniel. Thank you very much. Some of this, I'm sure for some of our colleagues online, was a bit of a refresher, which is very good to have. But I can see a lot of new material has been added as well. A lot of it very reassuring. You had a couple of slides and mentioned a number of points on safeguards and upcoming guidelines and due dates for those coming out. Perhaps the biggest point I want to draw upon immediately is the public consultation that you'll be doing. I didn't say it in my opening remarks, but again, as the EBO network, as your arm into the third markets outside of the EU, we very much want to be at the forefront of communicating to businesses and the governments that we work with here, how we can make this directive a successful one. So please do consider us in the lead up to that public announcement. Let us know in advance so we can make sure that we send that message wide and far and have a good consultation for you. With that, I'd like to hand over now to Anthony to fill in the blanks and tell us what else we should be thinking about.
Thanks, Adam, and thanks for inviting me and involving me again. I'm going to talk a little bit about try and focus on the sort of practical steps that will be needed to implement the obligations under the CSDD. I think Dan's given a really helpful and comprehensive presentation in terms of the key elements of the directives, and I'll try not to repeat too much in terms of what he said, but perhaps make some observations from practice in terms of some of the challenges in implementing these obligations, but also perhaps to give you some reassurance about what this means and the impact it's going to have on businesses, both businesses which are going to be in scope of the directive, but as Dan has explained, the directive has been explicitly designed to require businesses to think about adverse impacts in their value chains, which means looking at what suppliers are doing, looking at what other business partners may be doing, and working to ensure that there are no adverse human rights impacts or adverse environmental impacts occurring in those value chains. And so that means the impact of this directive is not limited to the companies that are going to be in scope. So larger companies with annual European derived revenues above 450 million, it's going to affect a much broader range of businesses all around the world because of that nature of the due diligence obligations, the way that they will apply in value chains. Dan has described, I think, the obligations. Just to remind everybody that there are, I think it's useful to sort of think about this in terms of three elements. There are due diligence obligations. I'll come on to discuss that in a little bit more detail. There is a transparency requirement. And I think that's important to think about that as a separate requirement, because what it means is not only do you have the due diligence obligation, you have to talk about what you've done in your due diligence, the decisions you've made, the risk assessments you've made, the actions you've taken. And that transparency and the reporting that will have to be done on due diligence will facilitate scrutiny of the actions that a company has taken, and will be used by other stakeholders to assess whether the obligations are being met. And so those two things, those two elements, I think, are very important. And then there's the climate transition planning obligation. Dan's described that, and I'm not proposing to discuss that in detail. It probably justifies a webinar all of its own to sort of talk about climate transition planning. I wanted to just touch briefly on enforcement and accountability, and I'm a lawyer, and so I get very interested in this aspect of the directive. I think, as Dan has mentioned, failure to comply with the obligations in the directive in relation to due diligence, that may lead to injunctions, it may lead to sanctions such as fines. The fines can potentially be very large, although there is language in the directive to say that they should be proportionate. I think another feature of the enforcement accountability mechanisms is that compliance with this directive is something that European authorities are going to take into account as part of awarding contracts for public procurement. And so there will be that incentive to ensure compliance in order to participate in various forms of public procurement. And then towards the end of his presentation, Dan was explaining the possibility that companies may face civil liability if they don't comply with the due diligence obligations, and that non-compliance causes damage, and that might be that has to be harm or damage to people. Now, I don't want to sort of overstate the risk of civil liability and litigation coming out of this directive, but the experience, certainly when France implemented a similar mandatory due diligence law, which applied to really only the very largest companies in France, but the experience has certainly been that there has been litigation, taking advantage of the provisions in that law, which impose civil liability in a similar way for failing to comply with the due diligence obligations. And so, I don't think you need to be alarmed at the potential for civil liability, but it is something to pay attention to. And as I mentioned at the beginning, thinking about that risk of liability by reference to both the due diligence aspect of the directive and the transparency aspect. So you have to tell the world at large what you are doing and how you are discharging your due diligence obligations. And so you need to think carefully about what you're saying as well as what you are doing, because this is where the risk will be in terms of potential civil liability. I've always found it helpful to think about also this due diligence in terms of it is a process, it is an ongoing process. And what I've tried to do on this slide is really to describe the features of the due diligence obligation in the directive, or the components of that obligation. And you see how this is something that is an ongoing process, and that distinguishes the due diligence obligations in the directive from the types of due diligence that you might otherwise be familiar with in a business context. So doing due diligence of a new business partner, or doing due diligence of a business that you might be seeking to acquire through an M&A transaction, where the due diligence exercise is about assessing a series of risks at a particular point in time and making a decision. The due diligence obligations under the directive are ongoing obligations and which build on one another. And so starting sort of at 12 o'clock, as it were, you have to think about integrating your due diligence obligation into your policies and risk management systems. So having a sustainability policy, having a human rights policy, having a policy about how you manage environmental impacts that might arise within your business and in your value chains. And those policies shouldn't just be sitting off in isolation in a silo, being looked after by the sustainability team. They need to be integrated into the risk management systems of the enterprise. And, you know, that's an important feature of this particular, the due diligence obligation as it's set out in the directive. So you have your policies in place. Once your policies are in place, you have to actively set about identifying and assessing and prioritizing your potential or your actual adverse impacts. And I'll discuss in a little bit more detail what that means in practice. After you've identified and assessed the impacts, you have to take action. You have to take actions to prevent those impacts, to mitigate those impacts. If impacts are actually occurring, you have to take steps to minimize or to remediate those impacts. So after you've gone through the risk assessment, there's this active obligation to do something about the negative impact or the adverse impact. You have to have a notification mechanism and a complaints procedure. So there has to be a way for stakeholders, people in the community, for example, who might be impacted by your business, to be able to tell you about that, to be able to bring complaints, to be able to notify you of issues. There's an obligation to monitor the effectiveness of your due diligence on an ongoing basis. There's an obligation to then communicate on what you've been doing in relation to your due diligence, and then it starts all over again. Because of course your risks evolve, whether your policies have been effective dictates whether you need to, you'll need to review your policies from time to time and update your policies from time to time to reflect that the risks in your business may be changing year on year or as your business expands and moves into new markets and new geographies. And that first stage really is very important as well, this process of identifying impacts. I think this will be one of the quite challenging aspects of this directive to implement, and Dan described how the directive defines adverse human rights impacts and defines adverse environmental impacts. And those definitions are exhaustive in the sense that they define a list of international treaties on human rights, on the environment, and they tell you which human rights need to be you need to have in mind, and they tell you which environmental impacts you need to have in mind. But it is a very broad range of human rights and environmental impacts which are potentially relevant for you to be considering. And it's broader than what many businesses might currently be doing. And so as the sort of legal frameworks and regulatory frameworks around sustainability have evolved, governments have introduced on a sort of relatively piecemeal basis particular obligations to consider particular risks. And so many of you from business, you'll be aware, for example, of the modern slavery legislation in the UK, in Australia, now in Canada, which requires you to think about the risk of forced labour and modern slavery, for example, in your operations and in your value chains. That is just one quite small, but obviously important, but quite small set of human rights that you're considering in that process. Businesses have invested a lot of time and resource in establishing their due diligence on that particular topic. What the due diligence directive now requires you to do is essentially go through that similar process of risk mapping, but in relation to a much broader set of human rights. And so that will be, this mapping stage is going to be very important. Equally for environmental impacts, by now We have mandatory climate reporting in many jurisdictions. Lots of businesses have been thinking about climate. They've been thinking about their climate risk exposures, their contribution to climate change, and doing a lot of work in that area. But you now have a very broad set of other environmental impacts that need to be considered as part of this mapping exercise. So this will be important. I think then, so on the one hand, this is a new and potentially onerous obligation that you have, but it is important to highlight, I think, what Dan has said, that this should be, that the entire obligation is intended to be risk-based. And in relation to this mapping part of the exercise, it's an important part of this step that you think about and prioritize impacts. And so which are the most severe impacts, which are the most likely, and that you then invest the most time and resource towards the impacts which are most likely to occur, or if they occur, are most likely to have very serious or very severe adverse effects. Dan mentioned some of the practical steps that might be expected once you've identified what your potential risks are, your risks of human rights impacts, your risks of environmental impacts. These are the types of things that you might then do to ensure that those adverse impacts are avoided, or to ensure that they are mitigated. And you'll see that many of those things actually will be steps that businesses are already taking. So having contractual assurances from your suppliers, from your business partners in relation to sustainability issues is something that is already a well-established practice. And so including provisions in contracts that suppliers will comply with your code of conduct, for example, or will comply with particular requirements in relation to environmental issues, or comply with particular standards, for example, relating to labour standards, employment conditions, etc. So this is an existing tool. This is something that people working in international supply chains in particular are already very familiar with. I think the challenge, and really related to what I said about the mapping exercise, is that the breadth of topics that will be relevant for your contractual assurances has increased. So now it might not be sufficient to only have clauses in contracts dealing with forced labour, which have become by now very common. You will need to think about having a set of conditions and requirements in your contracts that address potentially a broader range of environment and human rights topics. This issue of providing support to business partners, I think, is going to be very important, particularly in the sort of first few years of the due diligence coming into effect. You will have important business partners that this will be very new for them, thinking about human rights issues, for example, beyond the narrow topic of labour standards, will be something that will be new. And so there'll be a challenge for businesses about how you communicate those expectations to your business partners who are not themselves within the scope of the directive. They're smaller businesses which are your suppliers, etc., and they will need help to understand why you're asking questions, why you're demanding particular provisions to be included in contracts, etc. I'm not going to discuss all of the others in detail. I wanted to touch very briefly on the last two. I do think it will be important for businesses over time to think about how they collaborate with other businesses to effectively implement their due diligence obligations. That's in particular big from a perspective of efficiency of effort and resource. Thinking about ways to streamline the due diligence process, risk assessment processes, sharing information in a particular sector, for example, in particular supply chains, one thing that you often hear when you're trying to negotiate with suppliers about these sorts of issues, either from a risk assessment perspective or from the perspective of asking them to comply with codes of conduct, is that they say, well, we've just had to go through this risk assessment with somebody else, or we've just been audited by somebody else, or we have to comply with somebody else's code of conduct. Thinking about how you can reduce the burden, I think in particular in the supply chain, will be important. One thing to be careful about, I think, this is something that the European Commission has said it will encourage businesses in particular sectors to work together to make due diligence efficient and effective. You will need to think about competition law issues when you do that. If you're speaking to competitors about what to do about this, just be mindful of antitrust issues and risks as you do that. It will be encouraged, but that doesn't mean it's a free-for-all to start sharing information with competitors and doing things with competitors. And then I wanted to very briefly touch on termination or disengagement. And the Commission has said this is something you should only do as a last resort. I do think this is going to be something that is going to be quite a challenging area for businesses to navigate as a result of the directive, because the directive, it doesn't exist in isolation. So the European Union has also introduced the forced labour regulation, which will make it a criminal offence to bring products into the European Union and sell products in the European Union that have been manufactured using forced labour. So, on the one hand, you're told if you're engaging with a supplier and there's a concern of forced labour, of course, you shouldn't. Your first instinct should not be to terminate a contract or disengage. On the other hand, you will have a different set of obligations, for example, in relation to forced labour issues to consider. And so, it's something that you need to think through carefully. In some circumstances, there will be situations where termination of contracts and disengagement from particular relationships is going to be necessary. That brings me to the end of the presentation. I'll circulate this when it's done. It has some links to some useful resources, including actually the very useful FAQ that's been prepared by the Commission. And Dan's mentioned that over the next couple of years, the Commission is going to be publishing other tools and resources, which hopefully people will find helpful. I hope that I've kept time okay, and happy to deal with any questions, Adam.
Yep, great. Thanks very much, Anthony. So we have a chat box, so if people can submit their questions into the chat box, I'll ask my colleague Gigi to help read out some of those questions. While that populates itself, perhaps I'll ask my first question back to Daniel. As I said earlier, a lot of reassurance, I think, as more and more information has been communicated about, risk-based, appropriate, best effort, compliance. At the same time, it's not enough just to be paying lip service to it all. My question to Daniel is, what is it that you think is most misunderstood about the CSDDD today, and what would you like people to know?
Thanks. First of all, it's Dan, so it's not Daniel. Nothing against Daniel. I think we faced during the negotiations and in the run-up to adoption a number of let's say, or different forms of negative buzz around this legislation from various quarters, but many of them really, how should I say, without much merit on substance. So this is, I mean, the main misperception is, I would say, this is not about more paperwork and more red tape. It's it's not a reporting directive. It's really a legislation that requires behavioral change. So it's about how companies are doing business. And yeah, I also another let's say misperception is that this will be very burdensome and it has costs. No, we think it also has very important benefits if done properly, and if the companies take this seriously and embrace sustainability. It's not cost is more of an investment in their own resilience and long-term prospects. And there is ample evidence that it does make business sense to integrate sustainability in your business strategy. So this would be the main ones, I think, that we faced and still are lingering there somehow.
Yeah, no, I think Anthony said it well when he said it isn't something that you can just pick a box and then put it away in a silo and it'll take care of itself. It has to be integrated into the business. I really like that chart that Anthony had, that pie chart, that sort of being a continuing process. And some of the examples that he gave as well actually showed it's not that complicated if you just make those adjustments and just make it part of the process, including additional wording into contracts and things like that. We have a question already. Vicky has a question. Gigi, are you able to turn on the mic so she can ask the question herself?
Hi.
And identify herself too,
can you hear me?
Yeah, we can hear you. Where are you from? Myanmar.
So I've been based in Myanmar a long time, working with Eurocham there with Karina, and we're kind of the poster child for all of this, and have done a lot of work on human rights due diligence. I'm now based in London for reasons some of you on the call may know. I also wear two hats around multi-stakeholder initiatives. So I'm very interested, Dan, in how that rolls out. I'm on the ICOCA board and the Global Network Initiative board. And I'm also with Institute for Human Rights and Business now, doing less work on Myanmar. But so I had one point, which is that it would be really useful for the Commission in its guidance to start off from the point of view of encouraging companies to engage direct with stakeholders, rather than employing consultants as an intermediary, because it will actually work out better in the end and possibly even cheaper. And we are seeing so many stakeholders being consulted by, hello, we're Deloitte, we're here, talking to you on behalf of Schneider Electric or whatever. And that's probably not what Schneider is doing, so I don't want to pick on them. My two questions, one of them to Dan, is who are you expecting the national enforcement authorities to be? Because if one looks at the ones for the CSRD, it seems that is moving towards mostly the national competent authorities who are responsible for the accounting directive, who are, a bunch of financial supervisors who aren't really very versed in human rights. So I'm interested to know whether you expect there to be a separate group of national enforcement authorities. And the second is perhaps more a question for Anthony. I hear a lot, including most recently, we did a training in Bergen for companies on business and human rights, where you have sustainability people within the companies saying our corporate councils are trying to gag us. They won't even let us say things like, we abide by the UN guiding principles. So I would be interested in how we can guide lawyers to be helpful in this process rather than super cautious. Thank you very much.
Thank you, Ambassador Bowman. And I have to say, we've very much enjoyed and appreciated your insights in previous meetings, from the field and from your experience in Myanmar. The question on national enforcement authorities, yes, we very much look forward. The designation of these authorities is part of the transposition by the member states. So we don't know yet. We should know by the time they transpose. The deadline is 2 years from now. But the directive, mentions what characteristics these enforcement authorities should have, and we look forward to engage with them through this future EU network of supervisory authorities, really to ensure that the approach to enforcement is coherent and consistent with what this directive is trying to achieve. So certainly it's not a reporting focus. Reporting is only a small part, and again, for most of it, we rely on a previous directive. So it's really about behavioral change and doing the right thing in relation to human rights and the environment in the value chains. So we don't know who these authorities will be. We hope they will have real teeth and they will have human rights and environment focus. And we look forward to engaging with them once they're designated by the member states.
Then I think another question there for Anthony.
Yeah, thanks, Adam, and Vicky, thanks for the question. I mean, it's sort of I think very commonly comes up, and will particularly continue. It's a very important question in the context of the CS-DDD, because of course the CS-DDD moves us from the CS-DDD isn't sort of something that sprung out of nowhere, as Dan was saying. It sort of builds on what the European Union has already been doing in other areas in terms of the sustainability agenda and transition to a sustainable economy. It's part of an overall package. It also implements and it makes mandatory a sort of a system of due diligence, which is already set out in the OECD guidelines, in the UN Guiding Principles on Business and Human Rights, which many companies, of course, have already been complying with. But of course, the difference is it now makes it legally mandatory. Now, that's one reason that lawyers are going to have to be involved in giving advice on how to go about implementing it. I think on the thing, why is it that lawyers raise, always concerns about disclosures and sustainability statements, etc. My experience is my personal view is that because we're in a transition from this voluntary approach to sustainability, and where the emphasis was on presenting a lot of good news about what the business was doing, the efforts it was making with stakeholders, the due diligence it was doing, the risk assessments it was doing, and there's nothing, it's not a criticism of that approach. The requirements that have now been legislated in the European Union and elsewhere require businesses to give an honest account of their adverse impacts, to give an honest account of what they are actually doing in relation to their impacts. And that means where you, for example, have gaps in your due diligence, disclosing that you have gaps in your due diligence, that you haven't consulted with a particular group of stakeholders, that you haven't mapped your risks in a particular part of your value chain or in a particular part of your business, and being upfront about that. And so I think that's, generally, certainly in my advice about what you need to do to set about complying with these obligations, is that sort of requirement that you give an honest account of what you're doing. That is a very important element of this, including because it allows people to understand, what you're doing in relation to due diligence. How is your due diligence driving your decision making as a business? And so we do need to move from the sort of more high level statements like our business respects human rights, our business complies with the UN Guiding Principles, to much more detailed explanations of what that means in practice, what are the impacts that have been identified, what has been done about those impacts to avoid them. And this isn't supposed to be a session about the reporting directive, but the reporting directive has some very, very specific and granular requirements about this, and which are about ultimately allowing people who read the reports of a company, etc., to really understand what risks the business may face in relation to human rights and the environment, what the adverse impacts might be and what the business is doing about them at a level of quite, granular and specific detail. And, it is important from a legal risk perspective that's accurate, and it's not an exercise in only reporting the good things that a company is doing and the sort of the positive case studies, but also sometimes disclosing where there are gaps and disclosing where there may be real challenges and real problems.
Great, thanks, Anthony. And maybe we keep you in the hot seat for one last question here. We've got June Park, who has a question. I don't know if we can unmute him, Gigi, but he has a question for Anthony.
He can unmute himself.
Fine, I'll read the question then. For Anthony, could you provide an example on how antitrust and confidentiality issues could be overcome through collaboration with other entities, especially with international stakeholders?
Yes, look, so I can think of two examples, in terms of collaborations which, had a specific sustainability objective and were done being mindful of issues around confidentiality, issues around antitrust requirements. One is in my region, banks responding to or thinking about risks of how to do due diligence around risks of being involved in payments that might relate to human trafficking, and wanting to share information with one another about that. And now that's difficult because of antitrust laws. Their competitors sharing information with one another, also difficult because of banking secrecy laws in various places. But they found a way to sort of share information typologies of particular transactions that might have indicators that a transaction might be associated with human trafficking, for example, and found a way to share that information, and tested the idea with various regulators to make sure regulators were happy with how that information was to be shared. So that's one example. The other one I can think of was a group of resources companies in Australia who realised that all of the questionnaires they were sending to their suppliers on sustainability topics, particularly I think human rights topics, were quite burdensome for suppliers to always be filling out. And so they came together and sort of came up with a common standard, a common questionnaire with a view to try and reduce the burden on suppliers. And because they weren't sharing any kind of competitively sensitive information, etc., that was a low risk collaboration from a competition perspective. So there are two examples. I think increasingly you see companies trying to collaborate as well in relation to environmental issues, climate in particular, and there's plenty of places now where regulators are actively encouraging that and producing guidance on what businesses can do together. But of course, being mindful of the concerns about competition and antitrust, and I think that will be equally important with implementation of CSDDD, that those collaborations happen not just on the human rights topics but also on the environment topics.
Hope that was helpful for June. Ladies and gentlemen, with that, we're 10 minutes past the hour. I want to be respectful of our speakers' time and your time, some of you taking your lunch break for this. I think it's been an extremely insightful session. Obviously, a lot's been going on in the last few months, and I hope that was useful for everyone. Clearly, it's a big learning curve, and there's going to be a lot more that's going to be happening in the next 2 years. I hope we can continue with these presentations and information sharing. As I said at the very beginning, or in the middle, to Dan, the EBO network and our 50 members or 50 members around the world are committed to making this process as easy and clear for our members as possible. So working together with you and your colleagues is really, really important. Please continue to involve us, and I think in the next couple of months we'll be in touch with something else that we're working on. So thank you very much. for joining us today. Thank you to our speakers. Have a great night, a good day, and a good morning. Thanks, everyone. Bye-bye.
Thank you. Bye.
Thank you. Thank you. Bye. Okay.